All right, good morning, everybody, and welcome back to the Prestige webinar series, where we bring you updates and the need-to-know information in order to best navigate the growth of your business. My name is Melissa Inalfo. I'm the Client Success Specialist here at Prestige and your host. This morning, we are joined by special guest Samantha J. Monsees. So Samantha is an associate over at Trisha Phillips, and today she is going to be taking us through, guiding us through President Biden's path out of the pandemic plan. So as you can see here, we're going to touch on the vaccine mandate, which employers might be affected, what we know and what we don't know, and then also some changes that may be coming down the pike, right? Like how we're going to navigate employee accommodations, how the American with Disabilities Act can be applied within COVID-19. So we have so much information packed into today's webinar. Now, as always, everybody is muted, but we do encourage you to please use the Q&A feature of the chat where we can address your questions, if not now, but afterwards, and we will reach out to you directly. Now, if you need this information after today, as a reminder, this is posted on our website. So PrestigePEO.com/blogs. You can always find this there. And you can also check it out on the Prestige Perspective, which you can access through client resources right on PrestigePEO.com. And with that, I am super happy to just bring in Samantha and introduce her. So hi, Samantha. Thank you for joining.
Good morning. Thank you. Thank you for having me.
Of course.
So we'll go through various things today with respect to the proposed Osha ETS. That stands for Emergency Temporary Standard. But before we get started, just wanted to provide a brief disclaimer that much of this is subject to change. Some of the information that we've learned from the Department of Labor, we're pretty confident in, but there are still some unanswered questions. So keep that in mind as we go out the presentation today. And while I am an attorney and I do specialize in advising employers on how to comply with everything COVID-19 related, this is not legal advice. So just a brief disclaimer before we get started. So many of you may remember about 5 weeks ago, President Biden announced his path out of the pandemic plan. So it was a 6-pronged strategy to combat COVID-19. Those aspects of the plan that relate to employers are vaccine mandates for federal contractors and healthcare workers, as well as requiring employers with 100 or more employees to either ensure that their employees are vaccinated or receive weekly COVID-19 testing. And it also requires that employers provide time off paid for their employees to get the vaccination. So the vaccine mandate, we don't have a ton of details at this point because it has not yet been released. What we do know is that it will apply to all private employers with 100 or more employees. It's estimated that this is going to impact 80 million workers, also known as 2/3 of the country's workforce. So the rule is going to take the form of what we call an emergency temporary standard. Those of you who are familiar with OSHA, there's a whole plethora of standards. And typically, in order to get a standard added to the Federal Register, there's a somewhat lengthy rulemaking process that goes into play. However, there's an exception to that called an emergency temporary standard, and that allows the agency to enact regulations which it can enforce immediately if there is what they call a grave danger to worker safety. So that is the standard and rule upon which the ETS is going to go into play. What we do know is that those who are covered by this standard who fail to comply could face citations and penalties of up to $14,000 per violation. What we don't know is if that $14,000 is per event that there's a violation or per employee. So in other words, if you've got 10 employees for which you have not confirmed that they're vaccinated or you have not given them weekly COVID-19 testing, it's entirely possible that that $14,000 will be applied for each individual for which the employer does not comply. So could get pretty hefty. And of course, as many of you probably know, there have been lots of outcry related to this proposed ETS from public interest groups, employers, states, attorneys general. So it'll be interesting to see what happens once it's actually passed. So who will be covered? So all employers that are covered by the OSHA Act must comply with the ETS. Some of you may be more familiar with OSHA than others. I mean, typically you think about OSHA, you think about workplace safety and where there are hazards present, like construction, manufacturing, production. But the OSHA Act actually covers nearly every industry in some form or another. So what's surprising about this ETS is it is going to include office-based employers who don't normally interact with OSHA. So that could be insurance companies, law firms, professional office environments, financial institutions. And the million-dollar question is, when will the ETS be issued? Your guess is somewhat as good as mine. We did have some progress last week. So you all may remember on October 11th, Governor Abbott issued an executive order that restricted private employers' ability to enforce vaccine mandates. The following day, OSHA sent the proposed ETS to the White House for review. However, it's not available to the public. So it could be released in the coming days. It could take a few more weeks. When this was announced on September 9th, there was a stakeholder webinar that the Department of Labor conducted the following day, and their estimate on when it was going to be released was as expeditiously as possible in the coming weeks. So probably about as vague as you can get, but OSHA is under tremendous pressure to get this ETS in place, because the longer that they wait, the weaker their argument that there's a, quote, grave danger exists. So in the interim, and also in that webinar that was held on September 10th, OSHA officials have advised employers not to wait until the ETS is adopted, but to instead start thinking about how you're going to comply. If you're going to mandate vaccines for your workforce, if you're going to offer a testing program, and to begin thinking about doing that. So that is what we have been advising all of our clients to do who previously didn't have any type of plan in place with respect to vaccines. So once it's issued, which again could be tomorrow, could be next week, hopefully is not in November because the clock is ticking. But once it's issued, it will have immediate effect in the 29 states where federal OSHA has jurisdiction. And then it can remain in place for a maximum of 6 months before it has to be replaced by a permanent OSHA standard, meaning that a permanent OSHA standard will go through the traditional rulemaking process where there's advice and comment from the public, input from stakeholders, things like that, that are traditionally accompany a permanent OSHA standard. So there's states where the government does not have jurisdiction over workplace safety. And so those are called state plans, state agencies. So under federal OSHA, those state agencies have to adopt an ETS that's, quote, just as effective as the federal ETS within 15 to 30 days. And it depends on the state that you're in on what that timing is. So there's 22 states that are not under federal jurisdiction, but are instead have their own state plans, including California, North Carolina, Tennessee, and I've put an address there for you to go and see if your particular location is governed by a state plan. So many governors of these state plan states have already been very vocal about their opposition to the ETS. So we anticipate a battle between the state plans and federal OSHA. And a big question that many employers have had is how this is going to apply to remote employees. So in that webinar I referenced earlier, the Department of Labor did confirm that the ETS will not apply to employees who never come to work. So those who sometimes work from home but come into the office will be subject to the ETS. And if you've got employees who work from home but are out in the field, technicians, sales reps, on-site employees, things like that, those individuals will be covered. Another outstanding question that we don't quite know yet is about the 100 employee threshold. So the webinar did confirm that the count for employees to determine whether or not your particular business will be covered is going to be on a company-wide basis, as opposed to a per work site or per location count. It's possible that it could mirror how the FLSA treats related entities. So in other words, if you're a part of a group of companies, it's possible that all of the companies under that umbrella will be treated as one for purposes of the ETS and for getting to the 100 employee count. It's unknown at this point, but we're preparing our clients that that's certainly a possibility. So we'll just have to kind of wait and see. But typically, at least under the FLSA, if you're a part of a group of companies that has a centralized operations, your HR, finance, accounting, those types of departments are a part of the main company and branch out into the related entities. Typically, that will be considered what's called an integrated employer. And then all of those employees of all of those entities that are related will count for purposes of the employee count. It's possible that it'll just be per company. We'll just have to wait and see. Another unanswered question is how employers are supposed to collect and record all this information. Also unclear. You'll hear that a lot in this presentation, and I apologize in advance. We just don't know yet. Under federal OSHA record keeping requirements, medical records must be kept for the duration of an employee's employment plus 30 years. A vaccination record card is considered a medical record. So that's an extremely long time that employers will have to keep this information. So I suspect there will probably be some clarifying language in the ETS covering that, because that is a very large burden on employers. So more to come on that. We're hoping, or at least are optimistic, that there will be some sort of interim record keeping rule with respect to vaccination cards. And who pays for testing? This is probably the biggest outstanding question of the ETS, aside from when it's going to be released. So traditionally, under OSHA, if there is a standard that an employer is required to comply with, the employer is responsible for the financial cost of that. So, respiratory protection, PPE, all of that is the responsibility of the employer. So if this falls in line with traditional OSHA standards, it will be the employer's responsibility to pay for testing. That can get extremely expensive. It's unclear at this time what type of tests are going to be approved by the ETS. There are some rapid tests that are fairly inexpensive, but they're not incredibly reliable. There's several tests out there that are reasonably priced, but they're not FDA approved. In California, an emergency temporary standard was passed at the beginning of the summer, and there were specific information within that about the types of tests that could qualify under California's ETS. And it was very clear that those had to be FDA approved. So depending on whether or not an inexpensive test is appropriate and will comply with the ETS is unclear. Anecdotally, we have several clients that have started to do that analysis of how much testing will cost. And some PCR tests, which are historically more reliable than the rapid tests, those can be $150, $200 a pop. So if you've got, even a small handful of employees who are unvaccinated and they're going to do weekly testing instead, that can get really expensive really fast. The president also enacted the Defense Production Act to multiply the production of rapid tests. So it's possible that that order was done in some fashion to help implement the testing requirements of the ETS. But what we're seeing is some employers have decided to go ahead and mandate the vaccine because they just don't want to mess with having to administer the tests, record the tests, and obviously pay for the tests. And one other note, so under the CARES Act that was passed back in March of 2020, insurance is required to pay for the cost of COVID-19 testing that's medically necessary. And these types of tests that we're talking about under the ETS, are arguably not medically necessary because they're what's called surveillance testing. So it's possible that if you have gotten a covered test under your insurance policy that was covered, that perhaps it will not be covered under the ETS unless you're symptomatic or you have essentially a recommendation from a doctor that's medically necessary for you to get the test. Along with paying for the test is the question about how you pay for employees to get testing, what we call compensable time. So it's not clear at this time what the ETS will have. It has been our firm's guidance to pay for time spent testing. That includes travel time to the testing location. Osha did comment during the webinar that the employer will be required to provide paid time off or use existing PTO. And that was about as specific as they got. Under the Families First Coronavirus Response Act, you may remember that was the emergency sick leave that was passed back at the beginning of the pandemic. That act was very clear that employers could not require that employees use their accrued vacation, sick time, or PTO before they use the emergency paid leave. And several other state supplemental sick policies related to COVID followed suit. So it's unclear at this time whether OSHA will continue with that trend, meaning you may be required to provide additional paid time off in excess of whatever existing PTO your employees may have. But generally, time spent by your employees when they're getting an employer-required test should be treated as compensable. So if that time goes over 40 hours per week, you want to make sure that it's included in the regular rate for purposes of overtime. And you'll need to do an assessment of whether it makes sense to perhaps have a testing vendor come on site to help minimize the time spent getting tests. If these quote at-home tests are acceptable under the ETS, it's entirely possible that you can have the employees perform their own test, at the start of their shift. It's just a little unclear at this point, but definitely be prepared that you will need to pay for the time that your employees spend testing. Another question that we've received is with respect to unionized employers. So if you have a full or partially unionized workforce, you may be unclear about how to comply with the ETS in terms of what's already in your collective bargaining agreement. So it's unclear. Again, I'm sorry for saying unclear, but we just don't know at this point. But it's unclear to what extent these employers will have to bargain over the decision on how to comply. But at a minimum, you should be prepared to bargain with the union over the effects of the compliance with the ETS. And then non-union employers should consider the practical implications of compliance from a labor relations perspective. It's possible that your workforce may try to unionize, after being required to do these things. Is something you need to be prepared for. Not a huge risk, but definitely something to be mindful of. And we've seen proposed legal challenges thus far. The Arizona Attorney General had filed a lawsuit right after the ETS was announced, challenging it. For those who are not familiar with the legal system and kind of the procedure for that, you cannot sue over a law that hasn't been passed yet. So that was not successful, but once the law is passed, it's very likely guaranteed that it's going to be challenged. Like I said earlier, governors of many states have already indicated that they're going to challenge the ETS. It's possible that courts may block enforcement of the emergency rule or a part of the emergency rule until all of the challenges are resolved. As we talked about earlier, OSHA has to prove that there's a, quote, grave danger to workers. So there's a question about whether or not there's a grave danger to all industries. I think there's a strong argument that there's not, but certainly for some of those industries, healthcare, of course, but other industries where employees are in person, social distancing is not possible, things like that. Those industries are going to have a more compelling argument that there's a grave danger than, a traditional office worker that's not interacting with a ton of other employees on a daily basis. But we caution not to wait and assume that there's going to be legal challenges, because once the ETS is passed, we suspect that compliance is going to be pretty quickly enforced after that, somewhere between 30 and 45 days. So if you aren't thinking about it now, you should start thinking about it so you're not kind of left holding the bag. So what can you do in the interim? You want to make sure that you're adopting procedures for determining your employee's vaccination status. If you haven't already, I recommend performing a census of your employees to determine who's vaccinated and who's not, because that's the information you need to know to figure out how you're going to comply. And if you do a census and determine that a large majority of your workforce is vaccinated, then perhaps offering testing to those who are unvaccinated isn't going to be a substantial cost for you. On the other hand, a lot of employers, depending on the industry, have a very low vaccination rate. So it may make more sense to require the mandate as opposed to offering testing, because remember, the OSHA, any OSHA standard, and specifically the ETS that's going to be released, that is a minimum standard. So you as a private employer can mandate the vaccine from your employees instead of offering testing. There are some caveats to that. Montana has a ban on vaccine mandates for private employers. And as I talked about earlier last week, Governor Abbott released an executive order that is terribly vague and unclear, but it essentially creates 2 additional exceptions to vaccine mandates other than sincerely held religious beliefs and disabilities. And that's personal conscience. No one knows what that means. And those who have already contracted and have recovered from COVID. So more to come on that. I will note that if you are subject to the ETS in either Montana or Texas, the federal law will supersede the state law. So that state law will not prevent you from having to comply with the federal law. The ETS may require that you collect proof of vaccination, or may require that you simply attest to vaccination. So in other words, you may be in a position where you can designate someone in your organization to review vaccination cards either in person or over a FaceTime call, and then that person can simply verify in the company's records who is and who is not vaccinated. That's a workaround that employers can implement if they don't want to actually collect and store the records. You also want to make sure that you are aware of any state laws regarding confidentiality and privacy of medical records. A common misconception is that asking about vaccination status or collecting vaccination cards is a HIPAA violation. It is not. And actually, my firm just produced an article yesterday that explains all the misconceptions about HIPAA. So I encourage you to go take a view at that. It's a common misconception that all employers are covered by HIPAA, and that's just not the case. So as I said before, you'll want to figure out whether you're going to mandate the vaccine or you're going to allow your unvaccinated employees to be tested weekly. A lot of unknowns at this point. Certainly, if it is going to be the employer's responsibility to cover those testing costs, I think that's going to tip the scales significantly for some employers because it's just going to be incredibly burdensome to allow alternative testing. This is an extreme example, but we have a fairly large client that has about 8,000 unvaccinated employees, and they determined that if they offer testing for those individuals, it's going to cost them close to $40 million a year. That's obviously a very large expense. So whether or not they're going to have to foot the bill for testing is certainly very significant. So that's something that I know I keep reiterating this, but you really don't want to be caught off guard. So you want to go ahead and make sure that you understand who is and who is not vaccinated so that you can start calculating what the costs are going to be. And there's more than just the cost of testing, right? You're going to have to figure out how you're going to administer your policy, who's going to be designated to collect the test results or ensure that the test results are being funneled in the right direction and that they're done on the correct timing interval to comply with the standard. All of those administrative costs are things to keep in mind other than the true hard costs of paying for the tests and paying for the time spent testing. And you want to make sure you have a plan for tracking the test results. As I said before, you'll probably want to make sure that you've got certain individuals within your organization that are going to be designated for collecting and recording the test results, and figure out a time that you're going to collect the test results. It probably makes the most sense to have a designated day within the week that test results must be collected. Some employers have looked at, 72 to 48 hours before your shift, you have to have a negative test. That may be a requirement for, different venues and other kind of events that require vaccinated individuals, but it does not appear that that requirement is going to be in the ETS. So from an administrative standpoint, it probably makes the most sense for you to designate one specific day within the week that those who are unvaccinated have to get tested, and then just keep that on a regular interval. That's probably going to be the simplest for the employer from an administrative standpoint. And you also want to make sure that you are figuring out how you're going to address noncompliance. So if there's an employee who either doesn't get tested because they didn't get around to it or refuse to get tested, how are you going to handle that? What type of discipline are you going to take? And then what happens if an employee refuses to get vaccinated and you have implemented a plan that vaccination is required? So you want to make sure that you've got procedures in place so that when these things happen, you're applying your policies fairly across the board. As most of us know, if you are not applying your policy, whatever the policy is, fairly across the board, that can give rise to discrimination claims. So you want to make sure that all of your policies are consistent, applied even-handedly across the board, and of course always document any steps that you take toward any type of adverse employment action related to either of these scenarios. And you also want to make sure that you're developing a plan for how to handle accommodation requests. We anticipate, so currently the law is if you require a vaccine mandate, is you need to provide reasonable accommodations for those who have a sincerely held religious belief or a disability which prevents them from getting the vaccine. And we anticipate that that same law will be in place for the ETS. So if you don't already have a accommodation policy to address these types of exemptions, you want to make sure you get that in place. On our website, there are free resources, free accommodation forms, free accommodation procedures, all of that to help you get started. Our whole vaccine resource center provides a wealth of free resources for employers to help comply with the various federal laws associated with vaccine mandates. So you want to make sure that you're communicating what the accommodation process is and that you're documenting the accommodation process, and then be prepared that employees who cannot get the vaccine due to a religious or disability issue may request an accommodation from the weekly testing requirement. A common objection that we received to the vaccine is that the vaccine was either created or produced in some fashion from a line of fetal cells. What most people don't realize is that the majority of every over-the-counter prescription or non-prescription, Tylenol, Tums, Pepto-Bismol, all of those were created from the same line of fetal cells, and also that the PCR test was as well. So that may create some religious objections. So you need to be prepared to figure out how you're going to handle those accommodations and those who want to be exempted, not only from the vaccine requirement, but also from the testing requirement. And you also want to be prepared for OSHA complaints and inspections. So OSHA has a limited number of resources. There's only about 2,000 compliance officers, also known as inspectors, throughout the United States. So it's physically impossible for OSHA to regulate every single workplace that is going to be subject to this ETS. So what we suspect will happen is that employees are actually going to be the reporters of noncompliance. Everyone has strong opinions generally about vaccines, and if an employee learns that an employer is not complying with the ETS, they very well could report the employer, which would prompt OSHA to come out to your workforce and try to open up an inspection. If that happens, you want to make sure that you've got all of your training records and your COVID-19 response plan ready to go, because you will be required to provide that to OSHA. If you don't already, you want to make sure that you have a COVID-19 policy and that it's communicated effectively to your employees, because that will be an issue that will come up in the event that you are subject to an OSHA inspection. And then, of course, you want to make sure that you train your managers and your supervisors on what to do and what to say if OSHA shows up. Also on our website are several resources about how to prepare for an OSHA inspection. So I encourage you to go take a peek at that if you're unfamiliar with OSHA or OSHA inspections, so you're not caught off guard in the event that the government comes knocking. I talked earlier about the webinar that OSHA had on September 10th. And as part of the ETS, OSHA indicated that they're not going to have any additional listening sessions or input from outside groups because of the severe time crunch that they're under to complete the ETS. Oftentimes that is part of the process. So after the standard takes effect, businesses, public interest groups, unions will be allowed to submit comments to OSHA that theoretically will be considered when determining what the permanent standard is going to be. And Department of Labor indicated, like I said before, they haven't decided whether employers will be recovered to cover the costs of COVID-19 testing. So big outstanding question. Other considerations to keep in mind, so federal contractors, the executive order that President Biden signed goes beyond just those who are working on federal properties. So it's effective with contracts that are entered on or after October 15th, and it requires that employees must be fully vaccinated by December 8th, and there's very limited exceptions. In addition to vaccine requirements, masks and social distancing are going to be required at all covered contractor sites. So if you are a federal contractor, you've got employees working as federal contractors, you want to make sure that you've got a designated person at that location or for that location where those workers are for COVID-19 workplace safety efforts. An additional federal regulation that's coming down the pike is from CMS. So that is recipients of Medicare and Medicaid. That also has not been released, but we expect it to be very broad. The federal contractor mandate is very broad. And essentially any healthcare facility that receives funding from Medicare or Medicaid is going to be subject to this regulation. It's also going to require full vaccination. And if for some reason the healthcare provider is not covered under the CMS mandate, they most likely will be covered by the Osha ETS. If it's a healthcare facility that doesn't accept any type of Medicare or Medicaid and you're under 100 employees, perhaps you will not have to comply. But of course, you want to make sure that you're consulting with your trusted legal advisor, because you don't want to be caught mistaken and be subject to various penalties for that. Reasonable accommodations. So we'll go through this somewhat quickly. This could be a whole separate webinar, but generally employers have to reasonably accommodate an individual with a disability. Employers also have to accommodate an individual with a sincerely held religious belief, which we'll talk about in a second. So this is a requirement unless doing so creates an undue hardship on the business or creates what's called a direct threat either to the employee or to others in the workplace. So once you become aware of a disability request, you need to make sure that you're engaging in what's called the interactive process, which is exactly how it sounds. It's a conversation between the employer and the employee about what is preventing them from being able to get the vaccine, documentation from their doctor, as well as reasonable accommodations that the employer can make so that that employee can continue performing their job. So examples, and this is fairly broad, but generally reasonable accommodations that are acceptable under the ADA: job restructuring, a modified work schedule, reassignment, modification of equipment or examinations, training materials, and a temporary leave of absence. Those are all historically considered to be reasonable accommodations under the Americans with Disabilities Act. Accommodations that are not typically reasonable are accommodations that require an employer to eliminate an essential job function. So for example, if you've got a production worker that's working on an assembly line, being present at the job is an essential function of the job. So working remotely or reassigning that person to a position or creating a new position is not going to be reasonable. Another accommodation that's not going to be reasonable, getting that person a new supervisor, providing indefinite leave, or excusing misconduct. So as an employer, what is required of you? So of course, you want to make sure that you're not burying your head in the sand. If you become aware of the need for an accommodation and you don't understand the process, I highly recommend you consult with someone who does. This can lead to lawsuits very, very quickly if you don't do things properly. An employer may have a duty to unilaterally provide an accommodation. So not every federal circuit requires that the employer explicitly ask for an accommodation. So if you've got eyes and ears and you notice that someone has an issue, you want to make sure that you're addressing that. If you are not in HR, you want to make sure you're consulting with HR before you're approaching an employee about a disability or reasonable accommodation. Because you don't make sure that you don't want to have what's called a regarded as disability claim, and that's where you perceive someone to be disabled. Those individuals are just as protected under the ADA as those who actually have a disability. As we talked about before, you want to make sure that you're engaging in the interactive process. So as we talked about earlier, you are required as an employer to provide a reasonable accommodation unless it poses an undue hardship. So under the ADA, what is an undue hardship? So this is different. The undue hardship under the ADA is different than an undue hardship under Title VII. That's the statute that protects those with sincerely held religious beliefs. The difference being that the standard is higher in ADA cases. So in other words, you have to show a significant expense to the business to create an undue hardship, whereas under Title VII, it's a de minimis standard, which is significantly lower. So you want to look at what the nature and the net cost of the accommodation is, what the overall financial resources are of the employer, and then the accommodation's impact on the employer's operation, which is the ability of other employees to perform their duties, the ability of the company itself being able to comply with the accommodation without significantly impacting the employer's business. The other caveat that we talked about earlier is you have to provide a reasonable accommodation unless it poses an undue hardship, which we just talked about, or a direct threat in the workplace. So direct threat means that the employee must not pose an imminent risk of substantial harm, either to themselves or to others. So a fear of a future harm is not sufficient, and it requires an evaluation of risk that should be based on recent medical judgment and available objective evidence. In other words, the direct threat defense to not reasonably accommodating an employee is pretty high. So before you make that determination, again, I recommend you consult with someone who's familiar with this process, most likely a very experienced HR professional or an employment attorney that can help you work through the analysis to make sure you're in a good defensible position. So ADA in the age of COVID, so many employers shifted their operations to remote work at the beginning of the pandemic. And for many, that was a temporary fix because we were all under lockdown. Employers do not have to permit employees to work remotely if there's no disability-related limitation that would require such an accommodation. So in other words, if someone just wants to work from home and there's not a disability reason to do so, the employer is not required to offer that. So you want to make sure that if someone needs some sort of accommodation, that you're following your standard procedures for obtaining medical information that confirms that the employee actually has an impairment, what the restrictions are, and the recommended accommodations. And that is documentation that you would obtain from the employee's healthcare provider. And you as the employer can send the employee's physician a medical inquiry if you need additional information. You want to make sure you're getting an authorization from the employee to have that discussion with their medical provider, but you're not required as an employer to just take someone's word for it. You can certainly ask for documentation to support the need for the accommodation. So religious accommodations, I talked about before, there are two general accommodations, of course, except for in Texas. that you want to keep in mind. One's disability, which we just talked about, and the other is a sincerely held religious belief under Title VII. Title VII basically prohibits employers from discriminating against employees based on religion. So like the ADA, employers must make reasonable accommodations for an employee's religious beliefs. However, the undue hardship, as we talked about before, is significantly lower than the ADA's undue hardship standard. So under Title VII, the accommodation, in order for it to be an undue hardship, requires more than a minimal cost or burden to the organization. So a good example would be, we have a firm client that they provide services inside healthcare facilities, and their customer, the healthcare facility, is requiring that only vaccinated individuals be on site. They are, as the vendor, the hospital doesn't have to make any type of religious or disability accommodation, so that burden falls on the actual employer, which is our client, and they have 5 of 10 representatives that have sought religious accommodations. So it's going to be entirely impossible for 5 of their employees to not do their job. They just won't be able to fulfill their contract with their customer. So they're in a position where they're going to have to make some decisions about how to handle those employees with a religious exemption, because it's obviously going to be an undue hardship to the business to allow that employee not to work or to create a new job for that employee because of their religious exemption. That's a pretty extreme example that obviously rises to the level of beyond de minimis. It just kind of gives you an idea of what those scenarios look like. So what is a sincere religious belief? So we caution employers, generally you want to assume that an employee's request for a sincerely held religious belief is sincere. However, if you're aware of facts that give you an objective basis for questioning the religious nature of the sincerity, then you can be justified to request additional information. So for example, if you receive a bunch of exemption letters from the same online church from several employees, the church is out of state, you've never known of any of these employees to be involved with that, that's probably sufficient to give you objective evidence that perhaps the sincerity or the purported sincerity is not actually sincere. So if you get to that place where you feel like you have an objective basis, then you can dig a little bit deeper to determine whether or not the belief is sincerely held. And I've listed some factors there that the EEOC has provided that can undermine whether someone's belief is sincerely held. There's also a very detailed article that I authored on our website about how to deal with religious accommodations. So I encourage you to go and read that if you are confused about or just want some help determining how to navigate these requests. So similar to the ADA, if you have someone that has a religious accommodation, you want to make sure that you are engaging in the interactive process to determine what accommodation can be provided. So accommodations that you can consider, wearing a mask or an N95, submitting to regular testing, which of course we've already talked about, working a modified shift, reassignment, or remote work. Those are all possible accommodations, but again, it's an individualized inquiry, so it's very possible that those accommodations are going to burden you as an employer. So this is not a black and white. These are accommodations that will be acceptable. You have to analyze it with respect to your particular business. And you always want to make sure you're documenting the process. As I said before, we have model reasonable accommodation request forms for both disabilities and sincerely held religious beliefs on our website. So you're welcome to use those. I recommend whatever you use to make sure it's consistent and that you're documenting the process along the way so that you can avoid any type of accusation that you're not assessing these exemptions equitably. You also want to make sure that you're keeping all this information confidential. I recommend designating one, or depending on the size of your business, perhaps two people within your organization that are responsible for handling these exemption requests and determining what reasonable accommodations are available. And if you don't already, any type of medical documents should be maintained in a separate file from the employee's personnel file. And that's beyond just a vaccination record. Any medical information should be kept in a separate file from the personnel file. Okay, so that is yes, that's the gist of the webinar. I suspect some of you probably have some questions.
That's what I was thinking too. So first, though, thank you so much for this seriously packed webinar of information. I have a feeling we're going to have some follow-up questions. So what I will do, Samantha, is I'm going to, and for everybody who's in and who has been participating in our Q&A, we're going to extract those questions to make sure that we reach out to each of you individually, because no two situations usually end up being the same. So we can definitely review those items, and then we'll reach out back to you afterwards with our follow-ups. And I'm sure as the next few weeks and months come, we're going to have updates upon updates of things that are happening. So keep your eyes out. This definitely won't be the last conversation that we do have about this path out of the pandemic plan and the new requirements. So again, Samantha, thank you so much for coming on today. This was amazing. And as soon as it's posted on our website, we will notify everybody. For those who want to download the webinar and listen, again, that's prestigepeo.com/blogs. All of our webinars are going to be posted there. And so, please take advantage of that. And as always, we do love hearing from you. So as things are happening in the future, let us know what you want to see. That way we can make sure this content is catered to what you need. And again, thank you so much. And we will see you in a couple weeks.